Okay, all good. Shall we start? Ladies and gentlemen, good morning, good afternoon, good evening, depending where you are. I'm Ana Lucia Jacome, a specialist in human rights and good governance from the Division for People and Social Development at UNITAR. I remain at your disposal in case you want to explore possible synergies on aging and older persons learning initiatives. I warmly encourage you, all participants, to send your questions and comments to the speakers using the Zoom Q&A tab throughout the session. We are delighted to celebrate the 5th year of UNITAR's and other partners series on mainstreaming knowledge on aging. This year's series will be an opportunity to further explore the human rights of older persons from the security perspective under the clusters including legal protection, economic and employment security, political and civic security, health and social security, cultural, recreational, and digital security. The human rights of older persons and frontier issues such as the demographic worldwide scenario, gender, human mobility, digital divide, and climate change will continue as the heart of our discussions. In today's event and our discussion, we will be focused on legal protection for older persons. Without further ado, let me warmly welcome today's panel. We have with us, it's an honor to introduce our dear colleague, Madame Chitra Marie Massey, the Chief of Section of the Rights of Older Persons at the Office of the High Commissioner for Human Rights. She was the regional representative of the Office for the Pacific. She has also worked for several years on a wide range of human rights issues, which include street children, countering torture, business and human rights, countering discrimination, climate change, supporting youth to engage with and on human rights issues, strengthening national institutions' ability to work with human rights, including policy, military, armed forces, judiciary, and establishing national human rights commissions, working with civil society and non-governmental organizations. Please, dear Chitra, the floor is yours.
Thank you very much, Ana Lucia and colleagues. Very, very grateful for this opportunity to share some reflections on a subject that is very close to my heart, as you all know, and I'm very passionately committed to it. So it's also a privilege to share to be on the same podium, sharing thoughts together with such a wonderful set of colleagues who are formulating the panel today. So thank you very much for that. So let me begin with a very simple question. What do we already know? Because we all know we are meeting at a time of profound demographic change. And here we also know that populations are aging rapidly. And here, this is where I want to say is very much the case that we need to recognize that the world as we know it is changing. And by the time we reach mid-2030s, it will have transformed in ways that we are completely unprepared for. The second point on what do we know is that longer lives do not automatically guarantee dignity, autonomy, equality, or participation. Too many older persons still face discrimination, exclusion, inadequate care, digital isolation, and heightened vulnerability to harm. We all have been talking over the last 20 years, and we are talking that existing protections are scattered, are implicit, or incomplete, that they are leaving serious normative gaps. And yet, at the same time, I find that in spaces that we are all thinking that we are in the same, reading from the same song sheet, there are colleagues and stakeholders and policymakers that challenge this very, very clear understanding. What seems to many of us is very clear, that protection gaps are existing, that the existing protection that we are actually imagining under the current human rights legal framework is incomplete. Now, the fact is that there are serious normative gaps, and we have seen over the 14 years of the open-ended working group in New York that actually there is a compilation of exactly what these gaps are. And this can also be seen in the various reports of the special procedures, the independent experts, the UN Human Rights Office, the WHO reports, the ILO reports. It's a humongous amount of work and material. And yet, the question that is often thrown to many of us is, what are the gaps? What are the gaps you're talking about? So my job today, if I understood it correctly, is fairly simple. I'm going to talk and list out a few of these gaps that actually exist and we believe need to be addressed. So let's look at the first thing that is making older persons invisible: data gaps. Data gaps means that older people continue to be invisible. This is the sort of most commonly seen scenario. And then they can be the fact of extreme marginalization, marginalizing. What is it that brings these two words together? The fact that as a result of this, we are seeing violence, abuse, and neglect across the board. And then look at some of the things that we know very well and we have identified over the years. We're talking about autonomy. We're talking about long-term care. We're talking about access to justice. We're talking about healthcare. The autonomy, healthcare, long-term care, social security, the participation, these are all interconnected. And now we have seen increasingly that protection in emergency and humanitarian situations, including climate change induced movements and armed conflicts and variations of these settings. Because the world as we knew it perhaps 30 years ago, 40 years ago, is not the same world. And the challenges we see are often interconnected. Now, what is very clear is this: accountability is weak, implementation is uneven. Now, as we talk about this, I want to share two quotations with you to bring my message home. I'm currently in Baku at the World Urban Forum 13, but I was looking at what World Urban Forum 12 had to say. And so there was a very interesting experience from the last, which is about 4 years ago, where a grassroots organization shared that they were having training for emergency preparedness. And they said that when the flood warning came, it was a very good evacuation plan, but it had no guidance or steps to be followed for someone who cannot walk or someone who cannot walk fast. And so they had to deal with that situation to figure out, how do we actually respond to this in real life? How are we going to help each other? Then there was another point that was raised, was that the digitalization of pensions and health appointments assumes we all have smartphones and how to use them. And the reality is that while we are a rapidly digitalizing world, not everybody is comfortable with smartphones. And we can see that even in highly developed countries like Geneva. And so what is this? Is this dignity or is this designed exclusion? And most people are saying this is designed inclusion. So now let me look at what, which is very much often quoted as a very important standard to look at, the CRPD. And so even in the CRPD existing text, the data obligations are not necessarily as strong as we'd like to see them. So under Article 31, it imposes systematic data collection. But you have to also see what the rest of the framework is doing. And so what is the most commonly quoted legal framework when we are talking about, for example, housing? The Convention on Economic, Social, Cultural Rights, while it under Article 11 talks about right to adequate housing, at the same time, it does not ask for any data collection or puts any pressure on states to do this, because they were articulated, adopted, and became law and part of our framework at a different period where these were not issues that we were still yet grappling with. So basically, if you're looking at housing, for example, you're looking at what is a state voluntarily willing to do or not do. And we all know that housing is much more than mere shelter. So I'm not going to go into the 7 different elements that have been agreed from a human rights perspective on terms of this. But I'm going to just use one example to make my point within housing. And that is that if you look at a house at the center of our existence, if as an older person, I am making that choice that this is where I want to live. This is whom I want to live with, and this is how I want to live my life in the time of my age from 70 to 100, for example. But if the urban planning and the community and the city are not giving me access, not giving me transportation, is not giving me the accessibility to all these things which are very critical for me, that right to housing becomes, unfortunately, not a viable option. And so, this is where I want to bring in this phrase as distance increases for older persons from the services, autonomy decreases. And this is where I want to bring in the element of saying that whatever the challenges, the main point I'm trying to make is that structural change is very, very important. And structural ageism that we continue to see around us in the lack of engagement of institutions, public investment, labor markets, care systems, policy makers, and policy designs, these are all contributing to protection gaps. And so when we have this wonderful opportunity before us in terms of a recognition that even the most fundamental human rights, like an adequate standard of living, housing, health, information, and then moving on to the more complex and newly emerging challenges, such as the climate adaptation, digital challenges, all of these make me come to the point of saying, what is it that we need to do in terms of this, and what are we saying is the impact? Now, we often talk about dignity, and I think that we've all seen the call for contributions to the new legally binding instrument for July, and I'm very delighted that we're looking at many elements of the guiding principles. So dignity is there, participation is there, inclusion is there, autonomy is there. There are many different elements that will have to be unpacked. But I think as human beings, I keep coming back to this. It's very important to think that as an older person, you are entitled to a life of full human rights enjoyment, which must be equivalent to a life of happiness, joy, and fulfillment, and we must not separate this. So what is needed now? So I'm talking about a rights-based transformation. We are talking about grounding it in dignity, equality, accessibility, autonomy, participation, non-discrimination. All of these principles that we are all looking at. But there is something else I want us to look at together, and that is, as long ago as in 1995, the Committee on Economic, Social, Cultural Rights set out, it's one of its first general comments on the rights of older persons. And I'm amazed that it's 1995, the document, and we still haven't been able to integrate it into our approaches. A comprehensive, holistic approach, one that recognizes intersectionality, is fully grounded in human rights framework. It should be coordinated, multidisciplinary, attentive to interlinkages, all of these linked to a state's obligation, the threefold obligation, which is a basic fundamental of human rights law and framework: respect, protect, and fulfill rights. All of these, with all of these gaps that we are talking about, while recognizing very importantly that aging is not a homogeneous process. A one size fits all approach does not work and will not work. And the last point I'd like to make is that our failure to coordinate or take this comprehensive, holistic approach of intersectionality and a multidisciplinary approach is a failure that hits hardest those who face intersecting discrimination. All of us are familiar with, and we have been rooting for, a life course approach. So I take that fully on board and say, keeping that in mind, yet the reality is that there are still groups that are facing intersecting discrimination, and older women, indigenous people, rural populations are just a few.
I think there is a technical problem. Can you hear me, colleagues? Yes? Oh. Okay, so Chitra apparently is facing a technical
Make that.
Oh, here she's with us. She's in Baku now. She's in the World Urban Forum. Maybe there was a problem with the connection. So let's continue, please, with our next speaker, and later we can invite Chitra to continue. Chitra?
Sorry, I don't know
All good?
when. I'm sorry, I don't know when I dropped. I don't know. The internet connection just broke.
Don't worry, it was like 2 minutes ago. Don't
Okay.
worry.
So
Please,
I can
if you can
stop.
just...
I can stop, and maybe if there is time, I can come back to things later. But thank you. I'm sorry if I went over the time.
Don't worry. Thank you so much, Chitra. We understand you're facing some problems with internet, but we appreciate your time and availability. It's good that you are raising awareness on the importance of including older persons in the agenda in the framework of the World Urban Forum. As UNITAR, we are also happy to hold 2 events in the framework of this big event, and we are, of course, covering as one of the topics the importance of older persons in the agenda. Now we continue with Nena Giorsanti. She's the head of advocacy at the Age Platform Europe. She has spent the past 15 years advancing the human rights of older persons, working at the crossroads of research, policy, and advocacy for social change. She holds a PhD from the University of Galway, where she is also an adjunct lecturer and co-founded the Belgian NGO Droit de Banc, which uses law to rethink aging. Her expertise has shaped international initiatives from negotiating the Council of Europe's recommendation on older persons' rights to advancing the OHCHR, the UN independent expert on the rights of older persons, the UN Special Rapporteur on Disability, and the International Labour Organization, and is instrumental in promoting the EU's rights-based approach to aging. Please, dear Nena, you have the floor.
Thank you. Thank you so much for this opportunity. I'm one of the 3 Nena, Nina, Nino that you will hear today. So very glad also to be sharing this panel with so many distinguished guests and for this opportunity. So what I want to do today is discuss legal protection from the perspective of the realities of older persons. So looking into particular into some of the systemic barriers that older people face, be it legal, institutional, or personal barriers that are all linked to ageism. And I want to do that reflecting on my research that I have done for my PhD, where I was comparing 3 European countries, Ireland, France, and Greece. And what I did is that I did interviews with organizations of older persons on the ground, older persons themselves, and human rights actors, including NHRIs, equality bodies, and other human rights professionals. And what came from this discussion was I was trying to understand how people understand how they experience their human rights. Is there something unique in the human rights violations in older age, or is it just the accumulation of other types of inequalities? And how new convention could potentially improve legal protection on the ground. So what I try to explain in what I call the theory of overlooking the injustice is that ageism, what in my research was called discounting, and ageism in all its forms, which as we know, as Chitra explained, is very systemic, is pervasive, produces 3 very much distinct but also interlinked processes, which we'll go back to in a moment. And these 3 processes contribute to the systemic undermining of human rights of older persons. So what are these processes and why are they important in terms of legal protection? So the first process is non-recognizing. So non-recognizing is essentially not understanding, not having consciousness, not recognizing the wrongfulness of acts, behaviors, practices towards older people, and essentially trivializing, normalizing them, and pushing out of the remit, out of the purview of human rights law. And this happens in many ways. I'm just going to mention a few. One of them happens through law per se, or the absence of law, or the limitations of the law, or the interpretation of the law. So at a European level, for example, we have protection against age discrimination, but only in the field of employment. And even where we have protection, it is very much limited. So it is very much open to interpretation. It's much more legally and socially accepted. And the very courts that are supposedly there to protect rights use biases in their application of the law. So they tend to accept by default, for example, that capacity to work diminishes on the basis of chronological age. We also see language in the law, in the policy that we have, either at the national system or at the European level, where older people's rights can be enjoyed for as long as possible and not on an equal basis with others. And essentially that means that we are more likely to have limitations, more likely to have coercion, more likely to have institutionalization that is hard to dispute, that is hard to address and to redress. Another way in which we see that there is this process of non-recognizing at play is through institutional practices, including, that of human rights professionals who lack the language and the consciousness to detect and address human rights violations. And this has also been reiterated in other people's studies, including studies of social workers who were given exactly the same facts, and they were more likely to label the same facts as abuse if the victim was younger compared to an older person. Likewise, there is evidence showcasing that police and legal enforcement agencies tend to take older women who are victims of abuse as less seriously. So this is the process of both as individuals, but also collectively as a society. We do not tend to give the same level of severity. We don't have the same level of consciousness to recognize those issues as human rights violations. And this process of non-recognizing is then linked with what I call in my research non-enabling, which is essentially to the extent that we do not recognize the systemic nature of those human rights violations. What happens is that we tend to see them as exceptions, as rarities, as malpractices, as institutional abnormalities. So we don't see them as cases where there is state obligations and state actors have an obligation to act, to prevent, to address, and to offer redress. So we divest state actors from the responsibility to do something, to make changes on the ground so that rights can be equally enjoyed. So this is the process of non-enabling. And people were telling me, actors on the ground, telling me we don't have the language to describe human rights violations against older persons to the same extent that we have for children and women. And likewise, because there is discounting, because older people's rights are not considered in the same way as those of other groups, because older people are not considered as contributors to society. For example, when Ireland is being devising a strategy on lifelong learning, we have an age limit. So we not put in place the practices, the policies that are necessary in place so that everyone can equally enjoy the right to lifelong learning, to education. And this goes, of course, it can be applied to other areas of life. The same goes, people were telling me, violations of rights in care are not labeled as human rights violations. They're labeled as, social care issues. So basically, we don't have something to do there. Or cases of financial abuse, they're not seen in their full severity as theft, as human rights violations, but tend to be normalized and silenced and not given any visibility. And the third way this processes work together is by disempowering the rights holders or the persons, but also the organizations that work with them and for them, to support them and to advocate for their rights. To have consciousness and to have awareness so that they're able to claim their rights. So this is something, of course, that we see again also in reports and in research. We have surveys from the European level that demonstrate that people over 55 plus are less likely to know about their rights and about the tools that exist at the European level, including the Charter of Fundamental Rights, and in the Council of Europe, the revised European Social Charter, less likely to claim rights, less likely to do strategic litigation. From the World Health Organization, we know that only 1 out of 24 cases of abuse are being reported. And this is also something that people were telling me in my studies, and I have seen also in other organizations. So people saying it's okay that, I'm forced to go in an institution. This is normal. This is what happens to people of my age. Or it's normal that they didn't recruit me because I'm older. Or I don't have the energy, I don't have the money to fight for my rights because I'm older. So people do not raise their voice. Why? Because they also internalize the same stereotypes that we as society have. And this, of course, leads to silencing those voices and to not having adequate legal protection. So where does this result? So essentially, this theory of overlooking the injustice in simple terms is about the fact that ageism not only drives human rights violations, but this essentially makes those inequalities, those breaches of rights against older people seem natural or inevitable. So we don't do our best at society to address them. So we don't consider them with the same severity as other forms of violations against other groups. So this is where a UN convention can really help. How? First, the convention offers accountability, so it helps solve the problem of non-recognizing. Why? Because it puts in legal terms that these issues are human rights violations. It gives us the language to address those issues as human rights violations, and it enables us to detect those human rights violations. It also helps us to plan for changes, make reform, explain what are the changes that are needing to happen on the ground. It acts as a catalyst for those policy changes. So, and by explaining what are the obligations of state actors in particular, but also, of course, other actors as well. And then it creates space for participation and justice. It creates space for the rights holders, for older persons to participate in the monitoring, in the decision making, and to seek justice and redress by creating more awareness also of those rights. So essentially, when we're talking about legal protection, it's important to look not only in the legal terms in terms of what exists in the framework, but really think about how we can enable rights awareness among the rights holders and among the organizations that work with them to provide information about the availability of tools and the opportunities for redress, to support them in those claims and to empower them to be able to claim those rights. And also to do a work in terms of preventing the biases that we see in the law and the interpretation of the law, for example, through trainings for judicial and legal professionals, but also by having an obligation to review laws and policies and to repeal them when they are discriminatory. So hopefully this is a useful contribution for this discussion. I look forward to the others' contributions.
Thank you so much, Nena. Of course, this is quite useful. Understanding the meaning behind the language used goes beyond general knowledge. We should all be aware of the actions and their impact in people's lives. Law is not just theory, it shall be implemented, and the words used should be easy to be understood by everybody. We should all be empowered and know what is behind laws and the wording used. So thank you so much, Nena. As you mentioned before, now we have Nino. We have the pleasure to warmly welcome Nino Shalamberidze. My apologies, please, Nino, for the pronunciation of your last name. She works at the Office of the Public Defender, Ombudsman of Georgia. She has been there since 2012 as the chief specialist in the Department for the Protection of Civil, Political, Economic, Social, and Cultural Rights. She handles cases involving social rights. In addition, she employs the PDO's constitutional mandate to defend human rights of older persons. Welcome, dear Nino. Please, the floor is yours.
Thank you. Actually, I'm here from 2010, but it was my mistake when I'm sending you about my video. So it has been already 16 years. All right. First of all, I would like to express my gratitude for the opportunity to participate in this webinar and in this discussion. I would like to briefly outline the mandate of the Office of the Public Defender of Georgia regarding the older persons. Well, this Ombudsman's office is the only national human rights institution in this country, in Georgia, and holds a status accreditation. Over the years, the office has, the Public Defender's Office has been actively engaged in the protection of the promotion of the human rights of older persons, and has consistently supported the establishment of the above mentioned legally binding instrument for human rights for older persons. So this position is based on the findings and challenges identified through the examination of complaints older persons submitted, the monitoring of institutions providing services of older individuals like residential care institutions, the investigation of cases of violence and abuse against older persons. However, at this stage, I will not elaborate the specific challenges faced by older persons in Georgia, and the cases we'll deal with. These are addressed in detail in the annual parliamentary reports on the public defender, as well as the thematic special report. And I just put the link in the chat box of our web page where you can find these all reports. With regard to the older persons' limited access to the justice, the lack of adequate legal remedies, the low levels of legal awareness, the challenges they face is in fully participating in legal proceedings. Well, I cannot add anything novel. Similar issues is also present in Georgia. It's shared likewise in other countries. The first topic I would like to highlight is the excessive length of judicial proceedings. The report of the public defender constantly emphasizes that prolonged case proceedings undermines the right of a fair trial and reduces the overall effectiveness of the justice system. So case backlog then the resulting procedural overload lead to a delay in both civil, administrative, and criminal proceedings. So the public defender has pointed out that the situation is often linked to systematic challenges, including insufficient judicial resources and organizational insufficiency, so in court system. So these extended legal proceedings have the particular impact in certain groups, yes, including older persons, individuals with health conditions, those in a situation of social vulnerability. So as the element of time is often critical for the effective protection of their rights, and as it is important for such groups to judicial proceeding length with a reasonable time. Regarding the issue of affordability, national legislation does not provide benefits explicitly for older persons. Legislation in this direction is general and provides only for exemptions of insolvent plaintiffs from the state due to the cases of various categories, including the ones concerning social rights. At the same time, the legislation empowers the judge to decide in favor of full of partial exemption of plaintiff from the judicial costs by considering his or her income. A free trial legal aid system is also available here in Georgia, which enables any person to get legal advice in legal issue, drawing up legal documents, as well as representations in court and administrative bodies in the civil and administrative cases provided. But as for criminal cases, the Criminal Procedure Code of Georgia provides the mandatory defense of the defendant only in certain cases. However, it should also be noted that the rates at which older persons apply to these institutions, to this legal aid system, which is governmental body, for the protection of their rights and for legal representation before the courts, it is not high, which may be due to the low level of awareness among older persons. So with regard to accessibility, the state has not identified the needs of older persons with the policy document referred to the study of these needs and elimination of the identified problems only in relation to juveniles, persons with disabilities, ethnic minorities, women, children, so not the older persons. In addition, Policy documents or framework legislation do not generally provide for safeguards such as age-appropriate procedures to allow states administrative and judicial proceedings where it's necessary to ensure equal access to court for all the persons. Training programs for judges and other judicial staff do not include awareness raising or capacity building measures in relation to the negative effect of ageism or age discrimination and in the judicial system. However, the curriculum provides educational activities in domestic violence and international standards for non-discrimination. If we access to justice interpret broadly, older persons' ability to apply the public defender's office may be regarded as an effective remedy available to them. The public defender's office has regional offices, which further facilitates the accessibility for older persons. However, the public defender does not have the authority to represent them before the court, except the constitutional court and through amicus curiae submissions, but which may be considered insufficient to ensure effective legal protection for all the persons. Well, that is all I wanted to present now, and thank you for your attention, and I will look forward to discussions.
Thank you very much, Nino, for sharing your perspective from the Georgian National Human Rights Institution. Your insights bring an important approach from the country level lens to our discussion. Now, to continue, it's a pleasure to give the floor to Nina Kohn. She's a distinguished professor of law at Syracuse University, the Board of Advisors Professor of Law, the University College of Law, a distinguished scholar in elder law with Yale Law School Solomon Center for Health, Law, and Policy, and a member of the American Law Institute. She has served as a visiting professor at Yale Law School and Cornell Law School. She's leading expert in elder law, advanced planning, and medical consent, and the civil rights of older adults and those with diminished cognitive capacity. Professor Kohn earned an A.B. summa cum laude from Princeton University and J.D. magna cum laude from Harvard Law School. Please, Nina, the floor is yours.
Well, thank you so much for having me. It's a pleasure to join you all today to discuss the rights of older adults and legal protections for older adults. What I'm going to do today is start with a very brief overview of the law as it relates to protections for older adults. And then what I'm going to do is jump into tackling the larger question of whether the law should be allocating rights and responsibilities among adults based on age. So if we look across jurisdictions at legal protections for older adults, I think we can see these varying by three key variables. First, they vary by their source. So some protections are statutes adopted by legislative branches of government. Others are regulations developed by administrative agencies. Others are policies or principles reinforced by courts. Some are international, some are country level, some are regional, some are local. Second, if we look at protections, they vary in terms of their substance. So let's just consider a few of the categories of laws that we might think of as elder protection laws, right? There are those laws that protect older adults by offering positive rights, like those that provide minimum income or entitle individuals to health care coverage. There are laws that protect older adults' freedoms, like those that protect against age discrimination or involuntary institutionalization. And then there are laws that protect older adults by reducing threats that they face, like laws that criminalize elder abuse or offer services to those at risk of neglect, or that empower older adults to shape their own futures, such as those that authorize advanced planning tools like powers of attorney or advanced directives. And the third key variable is who the laws protect. Do they protect people in general? Do they protect older adults? Do they protect a subset of older adults? In recent years in the United States, for example, we've seen a proliferation of laws that respond to elder abuse by treating older adults differently than younger adults. For example, laws requiring members of the public to report abuse of persons, but only if those persons are age 65 or older. So as we think across jurisdictions and as the UN dives into drafting a convention to protect the rights of older adults, I think it's important to ask why we might want to use or potentially reject law specific to older adults. And to answer this question, I think we have to consider the purposes that age-based law currently serves in societies. So if we think about the functions of age-based law, there's 5 that I've identified as central in my research. One is we used age-based law to allocate resources to those who need them. So, for example, to the extent that we think that older people are physically or cognitively needier, or they're less resilient to financial shocks or other life events, then old age can serve as a proxy for need in the law. We may also use age-based classifications to promote equal opportunities. Indeed, often this rationale is used to explain favorable treatment for younger adults who are seen as having less opportunity. We also see age-based classifications used to prioritize people seen as deserving. Here, the notion is often that older adults should be rewarded for the contributions they've made over their lifetime. Age-based classifications may also function to mitigate against the terror of aging. Policies that provide public benefits or perks to older individuals have the potential to mitigate against the fear caused by anticipating or experiencing age-related declines in cognitive or physical or social well-being. And finally, we see age-based classifications used to exclude those who are perceived to be less able. So at times, age is used as a proxy for disability, facilitating what might otherwise be labeled as impermissible disability discrimination. Yet all of these uses have costs. For example, using age to allocate limited resources tends to result in poorly tailored laws because chronological age is a highly imperfect proxy for need, and this can also result in negative stereotyping of older adults. So these costs might be acceptable if we thought, look, the only way you could achieve these functions is through the use of age-specific law. But there's often really good alternatives out there. So resources, for example, can be allocated using means testing or based on more individualized assessments of vulnerability. Egalitarianism can be promoted by, well, rejecting law that treats people differently based on age, especially since favoring younger adults for resources may actually intensify inequality by contributing to the cumulative disadvantage faced by older adults from disadvantaged backgrounds. The deserving can be rewarded by using criteria that focus on individual conduct, not status. After all, how much people have contributed to their society is rarely well correlated with their chronological age. The terror associated with aging could be addressed by creating broad social safety nets for citizens. And if age is being used as clandestine disability discrimination, well, I think the law should prevent that type of subterfuge, instead insisting on employing the type of individualized assessments increasingly recognized as required when law overtly discriminates based on disability. So what does this mean? Well, these alternatives exist. Unfortunately, they may not always be politically feasible, and they may be difficult to implement. So if we look across these categories, I think the strongest justification for using age-based law is when we're allocating scarce resources or mitigating against the terror of aging. In the interest of the short time we have together today, I won't elaborate, but I will note that a full discussion can be found in the article cited on the slide, which came out this week. So let me close by suggesting an example of how legal protections designed to help older adults can benefit from actually rejecting age-based rules. So here in the United States, where I'm sitting today, advanced age was historically used as a basis for imposing a guardianship in many states. So, for example, under the Uniform Probate Code of 1969, which was a model for the states, a court could appoint a guardian for a person impaired by reason of advanced age in making or, frankly, merely communicating responsible decisions. So the aim of this approach was to protect older adults. But what it did was it encouraged judges to remove older adults' legal capacity based on stereotypes about older people. So today we have instead shifted almost entirely in the states to an approach that rejects this type of age-based approach and takes an age-neutral approach, such as seen in the current Uniform Probate Code, that focuses on whether the individual's functioning, apart from their age, falls below a certain threshold, and therefore there's an unmet need. What does this more modern approach do? Well, frankly, it offers older adults greater protection because it not only can serve to protect their person and property when truly unable to make decisions, and there's no less restrictive alternative, but it also provides greater protection of their right to legal capacity and their interest in being self-determining. So if we return to the question I started with here, does creating a legal regime that protects older adults require embracing or rejecting age-based law? I think the answer is ultimately neither, right? Age-based law can provide some valuable protection against age discrimination, and at times it may be a reasonable and frankly politically necessary way to allocate resources. But we should be carefully scrutinizing age-based classifications because their overuse may not only result in inefficient policy choices, but may promote the type of negative stereotypes about older adults that fan the flames of ageism. So I will end there. This is my contact information. Thank you for the opportunity to join today.
Thank you so much, Nina. It's been quite interesting to learn about some approaches on age-based law. This is really, really needed to identify legal gaps, not only from a protection perspective, but also for participation purposes. Now it's a pleasure to welcome back to our series our dear colleague, Jesse Schmidt. He's the director of advocacy initiatives at Harvard Law School Project on Disability. He has worked closely with self-advocacy and disabled people's organizations, both in the US and abroad, to advocate research and produce awareness-raising materials. His Spanish, English, and Bangla language materials have shaped disability rights, strategic litigation, and important decisions by national and regional courts. And his disability rights scholarship has appeared in collections published by Cambridge University Press and Oxford University Press, as well as both US and international law reviews. Please, dear Jesse, the floor is yours.
Thank you so much, Ana Lucia and the entire UNITAR team, as well as the broader coalition of organizations for helping to convene this really important and interesting roundtable. HPOD, my organization, has been proud to support this series and UNITAR's efforts to raise awareness on the rights of older persons for several years now. And this just goes to our belief as an organization that awareness raising is key and integral to breathing life into the legal frameworks and provisions that get discussed and are being discussed now in the Intergovernmental Working Group for Older Persons in Geneva. I feel slightly, I'm happy to be here. I feel slightly miscast following a lineup of Nina, and Nino, but I'll do my best to try to fit in, not by name, but in terms of some of the really interesting and provocative and helpful constructive ideas that they've put on the table in the short time that's allotted to me. I really appreciated, as always, the thoughtfulness that went into kind of putting together the concept note to kind of ground the conversation. And I think it particularly captures well the paradox that many older persons face with regard to legal protection when, even though this is a group that faces particularized and differential human rights violations, they also face age-related barriers in accessing the various systems that are designed to ward against and remediate those violations. So in my time, what I'd like to do is kind of touch on two things that weave in some of the concepts and the themes that the other speakers have addressed. And the first is I'd like to touch on how an emerging human rights treaty on older persons might approach the right to leave capacity of older persons. And then second, I would like to point to the possibility that checklists, assessments, and other tools that have historically been used to support legal capacity restrictions might be reimagined into safeguards against exploitation, specifically with regard to financial exploitation, depending on the normative values that they reflect and transmit. So just to recap for those who might be not aware, if I could ask the organizers to put the links I provided in the chat for people to access at their, if of interest, at a webinar that we hosted together with some other organizations at Harvard. We previewed some of these nascent negotiations of a new treaty for the rights of persons with rights of older persons. And panelists at that event emphasized something that really resonates with today's framing, which is that access to justice is not just about courts and lawyers, and systems of legal protections are not just about the provisions and the handholds that are available on paper. It's about how older persons navigate and access information and can, the usability of these systems to empower them and to support them to express their autonomy and make meaningful choices about their lives. And this new treaty process is really critical to shoring up the gaps in legal protections at least an international level, but also at a national and local level that the open-ended working group over more than a decade had systematically documented. One issue that I expect to be particularly challenging in the treaty negotiations is how this convention might address older persons' right to exercise legal capacity. And by that, I refer to the right to enter into and undertake legal obligations or make decisions that have binding effects on oneself and others. And this fundamentally will be, this negotiation around this issue will be informed by the values that ultimately win out during the negotiations. On the one hand, as Chitra mentioned, we know from the disability rights movement, which participated in the negotiations of the UN Convention on the Rights of Older Persons, which was adopted in 2006, automatically stripping people of legal capacity based on in that case, disability, but also, as Nino was referring to, based on age, is a form of a human rights violation and bad policy. Guardianship and other forms of legal capacity restrictions, once established, are extraordinarily difficult to unwind, and they can entrench abuse rather than prevent it, even if people entrusted with the care of older persons or persons with disabilities are family members or caregivers. On the other hand, there is a real risk and growing by the day of financial exploitation. And I would like to refer folks to the Center for Law, Brain and Behavior's white paper from last year on the effects of cognitive decline and its intersection with financial exploitation among older persons. And one of the signals that they include in their white paper is that even at a stage of mild cognitive impairment and independently, importantly, of cognitive impairment, people's financial judgment can be undermined long before anyone's capacity might be called into question in a formal legal way. The proliferation and increased sophistication of scams, such as using digital tools, deepfakes, and cross-border schemes, make this risk likely to increase rather than decrease in the coming years. And so a challenge for this new treaty will be whether negotiators choose to strike a balance between protection and autonomy preservation in the same way that negotiators of the CRPD did, or whether based on the values that are advocated for by civil society organizations and prioritized by governments, will strike a different balance. And that will be key. And I think the treaty can send strong normative signals in favor of how legal protection schemes at the national level can be designed in order to strike the right balance. There's a somewhat kind of, the second thing I wanted just to mention was how tools that have been traditionally used and deployed to restrict some of these rights might be reimagined into safeguards that can protect effectively against forms of exploitation that are increasingly on the rise. One specific example noted in this really helpful white paper was the case of Mr. Herrera, which I think helps to illustrate how effective legal protections for older persons have to take into account the environment and not just what the individual's characteristics are. In his case, he was a bilingual older adult who had passed or was subjected to a cognitive assessment that was in English, and the result of that assessment suggested that he had a moderate cognitive impairment. When reassessed in Spanish and with a culturally appropriate intermediary, he performed in a normal range, so to speak. Had that second assessment not occurred, he might have been misdiagnosed with dementia and opening the door to unnecessary restrictions on his legal capacity. While somewhat simplistic, I think this example illustrates how legal protections for older persons are inseparable from questions of language, culture, and the design of assessment tools and procedures, particularly the values, the normative stance of these tools and procedures, because the assumptions and values that inform their design and their use can lift up certain people based on certain characteristics inadvertently and push other people down independently of the thing that the tools are designed to measure. And so while which kinds of checklists and which kinds of regulations might be too granular for an international treaty to prescriptively specify, what the treaty can do and what the folks in the room and including myself can do is to argue for the treaty to embody and reflect certain normative values. and those could then inform and be incorporated throughout how these systems, including the tools and assessments and checks that are in place to help strike that balance between autonomy and protection are put into practice. Happy to share some more examples. I realize I'm at time and I don't want to get in the way of the robust question and answer session that always accompanies these UNITAR webinars. But I just wanted to say that these emerging treaty negotiations, regardless of the frames, Nina and Nina had given us really helpful frames of reference for evaluating the efficacy and of proposed treaty language or proposed legal provisions, regardless of the frame that we adopt. I think we all share a common goal, which is that whatever the treaty says or whatever words we believe might get states there, we want these systems for legal protection to be designed and adequately resourced in ways that generate the result of making these systems accessible, age-friendly, and effective. And that includes not just creating the right laws and policies, but also ensuring that not only the key actors, the individuals, including some of those who might be in the room today, who surround older persons in either formal systems of protection or more informal ways, have the tools and the know-how to incorporate and transmit the right normative stance in their interactions with older persons. And that has to be something that has to be part of that normative stance has to be a nuanced and culturally appropriate approach to balancing the goals of preserving autonomy and safeguarding and protecting people from abuse and exploitation. So thank you, and I'm happy to turn it back over to you, Ana Lucia.
Thank you so much, dear Hesi. You know how much we appreciate the support of you and Professor Stein throughout this process of the series. Since we started, you have been there with us. You know that deep inside, all the added value you bring to these discussions. And today you have brought some really interesting insights. You have stressed on additional challenges faced by older persons when it comes to legal protection, including financial exploitation and assumptions in the due process regarding accessibility caused by misconceptions. For sure, there are so many things to cover under each of the topics we choose for the 5 events of our series. That the idea every year is to keep building on that. But every year we try to keep building on that, and more things appear. So it's magic here. Now we will continue with the section of questions and comments. And Chitra, are you with us?
Yes, I am. I'm just to make sure the internet doesn't drop, I turn the camera off.
Perfect. Thank you so much, Chitra. There is one question. The following is for you. How can cooperation between developed and developing countries contribute to improving social and legal protection for the elderly and addressing the challenges of aging?
Okay. Thank you. Do you want me to go now or?
Yes, please.
Okay.
Please,
Okay.
if you can answer in 2, maximum 3 minutes, could be wonderful.
Okay, so I think that this is an excellent question because for me, what I'm missing is that the lived realities of people from the global south and lived realities of people who are exceptionally marginalized or are invisible even within this group of aging is very key. And I think this is what we are seeing in the last couple of months, especially given the crisis that is happening within the UN in terms of funding and resources, that this is a practical challenge. So on one hand, you have the cooperation at the governmental level, the state-led process and how can they work together on this. So let me see. This is me with my Christmas wish list. I say I wish that the member states and the wide number of support that this legally binding instrument and the process has solicited and resulted in. So we have 86 co-sponsors. The easiest answer for me to say for this would be to say, and this is what I've been pushing sort of quietly on the side, and I hope I'm not putting my foot in my mouth by putting it out in the open, is that like we learned from the CRD process, as a secretariat, we'd like to, sort of encourage member states to consider the possibility of putting together a small fund which would allow precisely this group of people from the global south, extra marginalized communities from all over the globe, to come and be actually there physically in the room. Somebody does not necessarily always have to speak up for them, but they should be there. So this is one element of this cooperation and discussion of making sure that the voices of those who matter and whose concerns need to be addressed are actually at the table. That's one part of it. And then we are looking at the much broader picture of resources. We are looking at the picture of supporting each other. And we've always been talking about cooperation between states. There are a number of international instruments. There's a number of resolutions talking about, South-South cooperation. Then you have the other triangulation, the developed world supporting the less developed world. So there are many different elements of this. They all exist. But in the current political climate, how much of this is actually materializing is something that we still have to work with. And so this is where I would actually come back and say that this is what we need to do, some active lobbying and get some people on board. And this is also a moment for doing a lot more innovative and creative thinking, that in light of the current crisis that the UN is going through, how can we ensure that this cooperation and support for each other, because remember, for me, one of the first points I made, and I hope at least that time I hadn't dropped on the internet, is that we know that implementation is weak. We know that accountability is almost non-existent. So if we don't have this strong will to do this and move ahead with this, structural challenges need to be addressed together. We have structural ageism, but we also have local action needed. And we also need a wide amount of collaboration, coordination, cooperation, and a lot of learning to do from each other. So there are many different levels at which this cooperation and support for each other can be done. So one small example, if I still have the time. So for example, we know that there are many cities under the age-friendly cities or the smart cities or the human rights-friendly cities that are doing something very good. You have societies like Japan or China, which are doing amazing innovation for older persons. But why is this not common knowledge? Why is there not more exchange happening? So if we actually start unpacking it, there are many different levels, at practical levels, where this cooperation and goodwill can be strengthened and made to work in a way that it works for providing sort of almost a very wonderful segue into saying, yes, this is what is the basic standards for the legally binding instrument should be, learning from these experiences. I will stop now. Thank you.
Thank you so much, dear Chitra. Now we have a question for Nena. Despite existing anti-discrimination laws, age-based bias continues in practice. How can such biases in interpretation and application of law be more effectively addressed, considering different contexts worldwide? Please, Nena, you have the floor.
Ooh, that's a tricky one. No, thanks so much for this question. It is actually very crucial in the work that we do, both at the European and also at the international level. I guess partially the reason why we're interested in the UN Convention is exactly that. So we see the new UN Treaty as the kind of frame. So a UN Treaty is not a silver bullet. It will not solve all the problems of the ground, but it will offer the frame through which we can. Professor Gerard Quinn tends to say that conventions are like mirrors that we put against society, and it showcases, the failure between the systems that we have and our aspirations. So in that sense, a new UN convention can have exactly the same effect when it comes to the rights of older people. So what are our aspirations, what are we aspiring to, which is a society that is equal for all ages, and the realities of our systems that reflect the biases, be it in the law, be it in the interpretation of the law, be it in the policies, and so on. So partially, we do hope that the convention will be able to deliver that in practice, to help at least deliver that in practice, and support that kind of transformation that we want to have in society. Of course, it will all depend on the content and the ambition that the member states will put into that treaty, but that's why it is really important for other actors, civil society, NHRIs, academics, experts, and others to contribute to that process as well, based on the experiences. And I was really interested to hear from all the different contributors about how they understand all that. And I think it's not going to be an easy question. And Professor Nina Kohn already mentioned, what does equality mean in practice, and where, some kind of form of differential treatment of the base of age will make sense. So it will be crucial to understand when, this is a bias, that is, a violation of dignity, and when there is reasonable reason why there might be, age-based differential treatment. So to do that, of course, it is a practice, a technical practice. It is a legal practice. So that will come later on. I think where it is really, if we set any kind of rule from the outset, is to think twice, or 3 or 4 or 5 times, when age is being used to limit rights versus age being used as a reason to deliver rights or to better protect populations. Perhaps also those will still reiterate biases, and I'm not suggesting that these are not to be reconsidered, and in some case they will need to be in any case reconsidered if they tend to stigmatize the older population. But certainly to the extent that they limit rights, I think that by default we need to have a system that does not allow, or that makes us scrutinize it in a more systematic way, where age is used as a criterion to limit rights. So that is one hand. But of course, the context will play a huge role here. So what I see from our work at the European level, for example, and I think that many of the legal systems here do not have elder law, so we don't necessarily have also perhaps the cultural, let's say, the culture of having age-specific, law. But we do have age discrimination law. We do have other systems that apply age-specific differentiations. But I'm mentioning the context and the culture, because we have, for example, members who come from Ireland, and then from a certain age, older people in Ireland have access to free public transport. And for them, this is a key, public benefit that reflects the realities of older people. Ireland being, a very rural country, and people have to travel around, and perhaps pensions do not cover those costs of living. And it's really important for them to get around and to remain independent and so on. Well, if you try to transfer that kind of age-based measure to the Netherlands, people will say, why? Why do we need that? Why are we discriminating, stigmatizing older people as being in need of more than other populations that might be more in need of a public transport ticket? So the context is going to be really relevant here. So in some contexts, think about age discrimination, for example. So if by default you say that, oh yes, member states should always, provide incentives for older persons to be employed, then that can be something stigmatizing, because it might reflect some biases in terms of older people not being as productive, and therefore, the employers need to provide incentives for the employers to keep them. So the state might need to provide incentives to employers to keep them. But if in a specific context, then we have identified that older people are more at risk of long-term unemployment or of being discriminated in the labor market, etc., then an age-specific rule might make sense. So it's not always easy to say where there are biases and where there are not, but there might be this overarching frame where we scrutinize our own laws, and where we start to understand also biases in the system in a different way. And this is where a new convention can help us reframe and rethink some of these. At least that's my hope.
Wonderful. My hope too. Thank you so much, dear Nena. Now we have a question for Nino, please. From your experience, because older populations often possess a smaller digital footprint their lived realities are frequently omitted from the data sets using to train legal and administrative artificial intelligence. How does this data invisibilization compromise their fundamental right to equal protection under the law? This is regarding new technologies and older persons, some challenges that they may face, and how these tools, instead of supporting them, could be against them to be invisible. Please, Nino, you have the floor.
Me, Nina, yes. First of all, if you allow me, I would like to comment this Alison Brown. She was talking about the data collected women over 45 age and above. Can I answer this? Can I comment? Yeah. So she says that I was shocked at the recent CSW meeting to be told that data on women is not collected for women over 45. So I was also, it was also a surprise for me when we find out that the domestic violence statistic in relation to victims, not only victims but perpetrators as well, used to be aggregated for persons aged 45 plus. I don't know from where this age came from, 45. So this means that all the persons were not separately identified, and the public defender issued a recommendation to the Ministry of Internal Affairs, which was taken into account, and now statistics are compliant separately for person age 65, 65 plus and above. So question was about the digital perspective and older persons, yes?
Yes.
So, and what is the our perspective as an NHRI, or how is the sorry again, I did not hear your question. So, digital perspective and older persons.
Yes, so it says, because older populations often possess a smaller digital footprint, their lived realities are frequently omitted from the data sets used to train legal and administrative artificial intelligence. How does this data invisibilization compromise their fundamental right to equal protection under the law?
Well, it's really affected while there's the development and digital technologies and artificial intelligence for older persons. We have so many cases, and older persons are approaching to us. It's hard to say about the artificial intelligence yet, but about the digital technology, how to use internet, how to use the mobile phones, and well, so it's this is the main issue for public defender's office now, and many challenge to work on it. And now we are trying to write down something about it, as something special report about the modern technology using by older persons. I don't have the exact answer right now, but we are working on this right now to that the artificial intelligent digital system can help older persons through assistive technologies for in the healthcare, to remote their healthcare and easy access to public services, and yeah, so on. So this is something we are working on now.
Perfect. Thank you so much, Nino. Now let's continue with Nina. How do current legal systems balance the protective measures of older persons, such as guardianships, with respect for autonomy and the decision-making rights of older persons? Please, Nina, you have the floor.
Thank you for that question. I think as we think about how do we balance the interest in protecting individuals with their interest in what is sometimes referred to as autonomy, one of the best things we can do is rethink how we're discussing autonomy. So historically, we've talked about this tension in law between protection and autonomy. And the problem with that is it suggested that either you're being protected or you're acting entirely on your own. And I think what we've seen with, among the other things, the emergence of a recognition of the role of supported decision making is that we need to be thinking not about autonomy, but about self-determination, about how can we make sure that individuals, to the greatest extent possible, are ultimately in charge of their own lives. And often we can maximize self-determination not through autonomy, but through partnership, collaboration, and support. Right. And so, for example, to the extent that older adults and others with cognitive challenges may have more difficulty making and communicating decisions, uh, partnering those individuals with trusted others or with technological assistance, or simply allowing them to make decisions in slower and more deliberative ways, right, may enable them to stay self-determining much longer and avoid the need to sort of flip into this protection mentality. So I think that's one of the most exciting things we see in the law right now as we think about elder protection is recognizing the ultimate goal is self-determination, not autonomy. And if we can do that mental shift, then we may find that there's actually less tension between the goal of respecting civil rights and the goal of protection.
Thank you very much, Nina. Now we have the last question. This is for Hesi. Hesi, you also have another question besides the one I'm going to do on the chat later. If you want to answer, could also be good. What emerging challenges do you currently see in protecting decision-making rights of older persons across legal systems? Please, the floor is yours.
Current challenges in protecting the legal rights of older persons across legal systems?
Decision-making.
Decision-making. There's a lot. But I think maybe piggybacking a little bit on Nina's remarks just now, one thing is, and also I think incorporating some of the really thoughtful things that Janine has placed in the chat, is that different individuals would prefer to optimize for different values within a same, like, system. And so someone might prefer a more self-determined life, and one might prefer something more relational or interdependent with others. And I think one core way in which many legal systems fail to protect adequately, or at least to enhance adequately people's decision-making rights, whether they have disability or whether they're older or what have you, is that now I see a little bit of a kind of like a pendulum swinging more in favor of autonomy preservation and self-determination enhancing means, and that might not reflect individual preferences at like a system level. And so one thing that I think is really worthy of exploring, and that I would like to see more of, and I don't have the exact answer to, are creating pathways for meaningful individualization in terms of what outcomes or what values you're optimizing for in your individual situation. An individual might be completely happy to be dependent and to delegate their decision-making authority to someone that they trust. Their next door neighbor might find that to be loathsome and reprehensible and how can we ensure that legal systems have adequate tools and pathways for both those individuals who have those different fundamental values? And so that's, I think, one struggle, not just like at the macro level. What does this system prioritize, autonomy or self-determination or protection? But at a more individual level, how easy is it for individuals to use the system to further their own values and to individualize and tailor the tools available to reflect those values?
Thank you, Jesse, for answering what could be the topic for a thesis. It's really good.
Yeah, it's too bad that Nina has already completed hers. Otherwise, I think she would be very well positioned to grapple with some of these questions.
Good. Well, thank you very much, all of you, for joining us today and for your active participation throughout the session. Your engagement and valuable feedback continue to inspire and motivate us to advance this important work. Our next event will take place on the 25th of June. Same time, focusing on economic and employment security for older persons. We look forward to welcoming you to this upcoming event. Please share this information with your contacts. After this event, we will be uploading the video recording, takeaways of the event at our online portfolio. And for those who attended at least 75% of the session, you will be receiving a certificate of participation from UNITAR. Thank you so much, and we wish you all the best. Thank you, dear speakers. We hope to see you in a near future opportunity. Take good care.